Wrongful death and probate. Hi, I'm Darren Findling of the Probate Pro. When somebody dies tragically from an accident or negligence, there is an intersection between Michigan's wrongful death statute and the probate statutes. So how do you navigate through these statutes? Well, the statute also determines how notice is provided when a lawsuit is going to be filed. Who is entitled to receive the notice of the filing of the lawsuit? And the statute dictates how the distribution will occur by either a jury verdict or if it's a settlement. How do you address the distribution of the wrongful death proceeds? Now remember, in Michigan, a personal representative is the only person that has the legal standing, the authority to commence and advance and file a cause of action related to the death of an individual. So probate is required. A personal representative needs to be appointed by filing either an application or petition for probate to appoint somebody to have the legal standing to serve in that role, to then advance the matter on behalf of the heirs and devisees and all the wrongful death claimants. In some states, other family members have the legal authority to have the filing authority, but not in Michigan, only the personal representative. So the letters of authority are the golden ticket to give you the authority to move forward. Once the matter is moving forward, then if a lawsuit is going to be filed, the statute dictates who is entitled to be notified so that they can present their damages, their losses that they've experienced as a result of the death of the individual. Now, here is kind of a basic understanding of how you determine whether the Wrongful Death Act applies or the probate statutes apply, and whether the funds from distribution will occur through the Wrongful Death Act or through the probate estate. And that is whether there was conscious pain and suffering. So for example, if the person dies and they experienced conscious pain and suffering from the accident, the negligence, then the person that died, are the parties that were damaged, and those monies will flow pursuant to the probate estate. Now there may be a will and there may be no will. So determining how it's going to flow will be dependent on whether it's testate with a will or intestate, no will. But what happens if the death occurred and there was no conscious pain and suffering? It was so instantaneous that the person didn't have time to experience conscious pain and suffering. Well, the statute, the Michigan Wrongful Death Statute, contemplates that then the injured party is no longer the person, but the family. And it defines who the wrongful death claimants are in the statute. So again, you can have a blur of two. You can experience conscious pain and suffering and die and have an allocation go to both wrongful death claimants and the people identified either in the will or intestacy. But there's a delineation of where that money is going to go. In addition, it's important to understand that when you're making this determination, you may need reports and evidence to support whether the person experienced conscious pain and suffering. Because if a jury is going to make this decision, they're going to have to allocate it. If there's no jury and it's a judge or it's through a settlement, generally it's proposed how the money is going to go. Now, many attorneys wrongfully just say, let it all go wrongful death. I call it the wrongful death theory. They just always assume, send it wrongful death. And it's misguided. You don't always want to do that because first, ethically, it may be incorrect. And then secondly, it can have a massive effect on where the money is going to go. Here's why. Think of a scenario where the decedent died with a surviving spouse and one child. Two people. If the money is awarded to the probate estate, only two people are going to take, the surviving spouse and the child. But if the money is going wrongful death under the Wrongful Death Act, the class of individuals who can claim are much larger. Let's understand what that means. The class includes the spouse, it includes children, descendants, meaning lineal descendants, it includes parents, grandparents, brothers and sisters, and it could include those named in a will. It also includes children of a decedent's spouse. So these are stepchildren, which do not occur in the probate-related context. So again, a much broader and wider net of claimants that can claim under the Wrongful Death Act than can claim under the Probate Act. So imagine if your client is the surviving spouse in the example that I was using, and you wrongfully decide, I'm going to just set it all wrongful death. You've just opened up the door for many, many more people to make a claim to the monies than simply the surviving spouse and the child through probate. So it's misguided just to assume it should go one direction or the other. The facts of the particular set of circumstances should control the situation, and working with a skilled, competent lawyer who understands the nuances of these statutes will help you go a long way in ensuring that the distribution is going to be handled correctly. In addition, you have to address the reimbursement of the funeral and burial expense and last illness, and there's a determination within that proceeding of whether there was conscious pain and suffering or not. So when you file the motion, you have to make sure that you give appropriate notice to the claimants as set forth in the statute. If there are any minors or disabled individuals, or legally incapacitated individuals rather, you have to appoint a guardian ad litem to ensure that notice is being provided correctly. So again, this issue about wrongful death, non-wrongful death, and how you apportion the money is a very important phase of this case. If you're an attorney and you've just maximized the amount of money available for the settlement, but didn't think through the distribution phase, you're really doing a client a disservice. If you've got questions about this particular Wrongful Death Act or the intersection between probate and wrongful death, feel free to contact us at the Probate Pro. You can reach us at theprobatepro.com or call 833-PROBATE.